Peace
Court words
family,
they
I'm
never
Eric
taught you,
Janelle
real
with the
examples
Nativa
that
Party
matter.
Nativa Alliance. This video is for educational purposes only. Let's walk through the words you hear in court, what they actually mean, and real examples so you can picture it. You can learn more or join us at nativaparty.org. 1. Objection, meaning you're asking the judge to stop a question or statement that breaks the rules. Example, the prosecutor says, "Your cousin told me you confessed." You say, "Objection, hearsay," because your cousin isn't in court to be questioned. Takeaway, objection. Mark, pause, judge, that's unfair or off limits. 2. Brady rule, meaning the government must give you all evidence that could help prove your innocence. Example, there's body cam footage showing the officer started the fight. If the prosecutor hides that, it's a Brady violation. Takeaway, ask for all Brady material so they can't keep evidence secret. Jurisdiction, meaning the court's power to judge you. If they don't have it, the whole case is void. There are 2 parts. 1, subject matter jurisdiction. Does this court handle this kind of case? Example, traffic tickets belong in traffic court, not small claims. 2, personal jurisdiction. Do they have legal reach over you? Example, you live in Florida. A court in Alaska can't fine you for a Florida ticket unless you were properly served and agreed to appear. How to test it. Ask the judge, for the record, is this a court of record under Article 3 and has jurisdiction been proven on the record? If they can't show lawful service, a sworn complaint, and your consent, jurisdiction is still in question. Takeaway, never assume they have power. Make them prove it on paper. Standing, meaning only the person directly harmed can bring a case. Example, you can't sue over your neighbor's ticket. You weren't harmed. In child support cases, if the agency files but can't show it spent public funds, they may lack standing. Takeaway, standing. Child, who's really the injured party? 5. Foundation, predicate, meaning you have to show where a document or statement came from before it counts. Example, you wave a paper in court saying, "This proves I paid." The judge stops you, no foundation. You fix it by asking the witness, "Is this the receipt you issued me on June 12th? Now it's authenticated. Takeaway, always explain what a document is, who made it, and why it matters before using it. Pleadings, meaning the written papers that tell the court what's being fought about. Example, if your complaint says wrongful garnishment, you can't stand up later and argue false arrest. It wasn't in your pleadings. Takeaway, if it's not written, it doesn't exist to the court. 7. Prima facie, meaning on its face, the minimum proof you need to keep your claim alive. Example, you claim a landlord violated your lease, show the signed lease and unpaid repairs. That's prima facie evidence. Now the judge must hear you. Takeaway, bring at least one clear piece of proof for every claim. 8. Motion, meaning the way you move the court to act. Example, motion to dismiss for lack of jurisdiction means you're asking the judge to throw it out because power wasn't proven. Takeaway, talking isn't enough. Every request should be a motion. 9. Offer of proof where proffer, meaning if evidence gets blocked, you describe it for the record so you can appeal later. Example, judge says, "I'm not letting that video in." You reply, "For the record, the video shows Officer Smith striking first. I'm making an offer of proof." Takeaway, always preserve your evidence on the record. 10. Opening the door, meaning you mention a topic that lets the other side bring in things that were off limits. Example, you say, "I've never had trouble with the law. Now the prosecutor can mention your old case." You open the door. Takeaway, don't volunteer extra stories. Answer only what's asked. 11. Burden of proof, meaning the level of evidence needed to win. Example, criminal, beyond a reasonable doubt. Civil, more likely than not. Takeaway, make the other side carry their burden. Don't take it on 12. Yourself. For the record, meaning whatever you want, preserved for appeal. Example, before leaving, say, "For the record, jurisdiction has not been proven." Now it's in the transcript. Takeaway, if it's not on record, it never happened. 13. Brady hearing, due process, meaning a special review when you think evidence was hidden or the process wasn't fair. Example, you find out later there was a witness who cleared you. You file a motion for a Brady hearing. Judge checks if your rights were violated. Takeaway, due process means fair notice, fair hearing, and impartial judgment, nothing less. Family, every word in that courtroom has a purpose. When you know what it means and can give examples, you control your space. Again, this is for educational purposes only. Join us at nativaparty.org to keep learning through the Nativa Alliance. Education is elevation. Erica Trenol, and Nativa Party.